Well, it's Wednesday night, and that means Life Ahead night here on PBS Fort Wayne. I'm Sandy Thomson, the host of the show. If you haven't watched us before, I encourage you to put Wednesday night 7:30 on your calendar. We have different topics each week, and as a goal here at PBS, we try to provide you with information and education that will help you make choices and decisions in your life ahead. That's why we have the name Life Ahead. Well, tonight we are talking about asset protection and elder law and how that all combines in a way to help you make sure that you are ready for protection, if you will, with your finances if you reach that point in your life. With me tonight, no stranger to our show, I have Bryan Nugen here. Bryan, thank you for coming.
Thank you, Sandy, for having me. I appreciate it.
Good topic.
Thank you.
Good topic.
Thank you. I appreciate that.
And I will tell you that Bryan, by the way, is specializes in elder law, so you've had a lot of experience. 30 years or something like that.
30 years, believe it or not. Yeah.
Yeah. So you've had a lot of people that you've helped or have come to you with issues.
I think so. Yeah.
Well, asset protection. Let's first of all just define assets. People think money.
Right.
Money in the bank. Not necessarily that's all there is, though.
That's right. It's not just money in the bank. It's anything that has a value. So that could be your real estate, to your point, Sandy. That could be money in a checking account, money in a savings account. It could be a life insurance policy that has a cash value. So if you cashed it in and it has a cash value, that would be an asset. Lake property, farms, stocks, bonds, CDs, IRAs, qualified money. So anything that has a value more so than just cash. Those are the types of things that we're thinking about in elder law, about protecting if our health may change or we're concerned about how to provide payment for that care as we age. How is it that I make sure that I don't lose the farm, that the house doesn't have to be sold to pay for me?
Right. And I know you and all attorneys that come on the show always promote early intervention, early planning. What's the purpose of that, Bryan?
So normally we like to see, if you're going to engage in asset protection, we like to see you do that as early as possible. And typically the key number of years is 5 years. We like to see assets protected and sheltered at least 5 years or more in advance. And the reason for that is that if you're looking for a benefit program to provide payment for your care, like a Medicaid or like a VA, Veterans Administration, they have timelines where they would be looking at, in the past so many years, 3 years for VA, 5 years for Medicaid. So they want those assets out of your hands and protected before you need to have that care paid for. So ideally, Sandy, we like to see, elder law attorneys like to see our clients trying to protect those assets 5 years or more in advance.
Yeah.
It's never too late to protect assets, but 5 years is the key if we can get it.
Now, you said 5 years in advance, but it's hard to know when you're 5 years away from needing additional care, whether it be memory care or a retirement home or some sort of facility. So how do we guess when we're 5 years away?
Well, the first thing that we would be looking at is the individual's age and the individual's health. We are also looking at within their family, what your parents, your grandparents, were there instances where at a particular age they were needing that level of care. There isn't a magic number for every person that said by a certain age you need to have something in place, or we're really looking at that individual, what's their health? Do we have an early onset dementia? So those 5 years, we may need to start that earlier. Do we have a cancer that maybe has gone into remission, or so we're thinking about, gosh, that could come back, and we're thinking, I may need more of that help in the future. But generally, I like to say to people, by 70, 75, I really like to see those assets protected in typically a very unique type of a trust that we use. I like to see that done so that you have the 5 years. And generally, folks that are in their 60s, maybe early 70s, they're still spending, they're traveling, they're doing those types of things. And so that when we protect those assets, they may not have as much freedom as they once did. Not that we couldn't still access funds if necessary, but they may not have as much freedom as they once did. So if you're still in spending mode and you're still having fun and doing those types of things, your 60s may be a little too early to start thinking about that. But I would really like to see, or I encourage folks to think about that during their mid-70s. Typically, people spend when they retire. There's kind of a spending pattern that they go into. And then when you hit your mid-70s, early 70s, your spending kind of plateaus and may even slow down a little bit.
Sure.
So when we're looking at that arc.
At that point where you're at
when
the
you're starting to
peak
slow
and-
down a little bit, right. But if you wait too long, then you may not have the 5 years. So I always give my grandparents as an example, my great-grandfather as an example. My grandparents passed at 100 and 101. So
Oh,
they
my.
could have done this at...
You have good genes then.
Yeah.
That's
but
great.
94, 95, they could have been doing this. And yet other folks at 67 may have some serious health issues, and we're concerned if they have the 5 years. So it is unique to each person, and I would encourage any of the folks that are thinking about doing this type of asset protection, be candid with the attorney that you're working with. Let them know what's going on, what your concerns are, what your health condition is, because it's going to help him or her to assist you in giving guidance about what's the appropriate time for that to be in place.
I understand. We do have a phone call, and then I want to get
great.
back to the asset protection issue. Kevin called in. Thank you, Kevin, for watching our show tonight. And he says, after a person has passed and assets have been dispersed, how long do you have before Medicare swoops in to take any remaining funds? Pretty
first-
interesting question.
Yeah, well, thank you very much, Kevin, for calling in. I appreciate the question. So what you used the word Medicare. So Medicare doesn't actually look to have any type of reimbursement if Medicare has spent money on your behalf. However, Medicaid does have the ability to come in and make a claim in your estate if there is an estate. So if there's an estate that's opened, when you've passed, the personal representative or the executor in the estate has the responsibility to put Medicare on notice that you've passed. And then they are...
Medicare or Medicaid here.
Thank you. I'm doing
I got
Kevin.
you on that
Thank you, Sandy. We have to put Medicaid on notice that you've passed, and then they have the ability to come in and file a claim in the estate. But frankly, if you're doing appropriate asset protection either early, or I use the phrase crisis planning. Crisis planning mean we didn't have those 5 years and you have a nursing home placement, memory care unit placement. If you're working effectively with your elder law attorney, in that instance, you shouldn't have the responsibility to open an estate such that Medicaid could come in and file a claim and be reimbursed for any money that they've spent on your behalf. But if you haven't done that and you open an estate, in that instance, we do need to put Medicaid on notice that the person has passed, that money has been spent on their behalf, and Medicaid, we're giving you the opportunity to file a claim in the estate for us to reimburse you.
How long of a time does Medicaid have to question your estate or turn in a bill, if you will?
Yeah, if I'm not mistaken, there's a 7-month period for Medicaid where they have the ability to open an estate, to file a claim, to come in. If one hasn't been opened. So it's a great question, Sandy, and I don't mean to be evasive. I'm thinking it's 7 months for Medicaid. Traditional claims in an estate, if we open the estate, they have 3 months within which they can file a claim. So that would be like a credit card company or somebody that believes that you owe them money. They have a 3-month period if you open an estate. Now, if you don't open an estate, this is deviating a little bit from the Medicaid question, but if you don't open an estate and you wait for 9 months and a day, any unsecured debts would be like the credit cards I was talking to you about earlier, or if somebody believes that you owe them money, if you don't open an estate or you open an estate in 9 months and a day, if they don't open an estate on your behalf or on behalf of the deceased, then they've waived the right to be reimbursed from the estate. So sometimes you'll see attorneys waiting 9 months to open an estate. So if there are some creditors out there that we're not sure about, or we're trying not to provide payment to those creditors, we may wait 9 months and a day before we open that estate.
Okay, let's go back to the terms Medicare and Medicaid.
Yes.
It's so complicated. I wish they had really different names for them because they are very different animals.
Even I mixed them up. So everybody that comes in does that.
Yeah, right. I do that all the time
Sure.
on this show. Yeah. Okay, Medicare, everybody gets when you've retired. And that's what you sign up for, and you get your Social Security check, and you get Medicare, some Medicare assistance medically. Medicaid, on the other hand, not everyone's entitled to Medicaid or is eligible.
So Medicaid eligibility for the type of work that I'm talking about with mature folks, we're 65 years of age or older, and we have some type of a cognitive, so our memory or our thinking process is a little muddied, or we need assistance with something called ADLs, activities of daily living, bathing, using the restroom, dressing ourselves, grooming, remembering to take medications, those types of things. If you are determined to need assistance with those ADLs, activities of daily living, have some type of a cognitive impairment, you're at the particular age, that's the first thing that Medicaid is going to look at. Do you qualify based upon age and based upon some type of a condition? Then Medicaid is going to look at the income and asset side of the equation. So they're going to look at your income. Is your income too high? And how many assets do you have in your name? So remember, it's even if your income is too high, there's a way to reduce your income in a way that Medicaid recognizes as an appropriate way to reduce it. We use something called qualified income trusts. You'll hear some people also say Miller trusts.
Miller trusts.
Yep.
Okay.
So if I have an income that's over the threshold of what Medicaid considers appropriate, our money comes into our personal checking account or savings account. We then take it from that and put it into this qualified income trust, Miller Trust. And then from the Miller Trust, we use the money to pay for our care. It could be in home, it could be an assisted living facility, could be at a nursing home, memory care unit. And if we pass away and we haven't used all the money that went into that Miller Trust, that qualified income trust, the money then goes back to the Medicaid in the state in which you live. So it would go back to Medicaid to reimburse them for funds that they spent on your behalf. And then the second part of the asset and income equation is assets. How much money do you have in your name? So the threshold currently is around $2,000, which seems very low. So back to the point that you were asking about earlier, Sandy, that if we've protected our assets in advance, if we sheltered them in a very unique type of a trust, they're still there, they haven't gone anywhere, but Medicaid recognizes that it's been out of your hands for a period of 5 years or more, so we're not going to look at that money as being available to you. Assuming that the trusts are drafted appropriately and we have all the right things in place and the right people in place to manage the money, Medicaid would ignore that. If you didn't do that asset protection in advance, we might consider means of protecting those assets at the time you're going into the nursing home, or if you've been there for a period of time and you thought you were coming home but you aren't. So what can we do? There are still processes that can be recognized and put into place to protect assets at that time.
So it's never too late to plan.
Late. Nope.
So even if you're in a facility,
yes,
or you're receiving daily at-home care,
yes,
you can still work on protecting your assets.
Without a doubt.
What's different about it doing it then as opposed to 5 years before you get to that point?
Sure. So generally what I would say is that if you're a single person, we normally can protect real estate. That's not as much of a challenge to protect. That does depend upon the state in which you're living, because every state is different about how you can or cannot protect real estate. But generally, real estate is one of those things that's a little bit easier to protect. And then, so if you're a single person, other assets aside from real estate, I generally say 50% or more can be protected based upon your income is one factor that we look at, and another factor is the cost of care. If you're a married person, generally all assets can be protected even at that time. And any of the techniques that are used, there are certain types of annuities that are implemented, there are gifts and notes that are implemented, but any of those processes that are put into place, those techniques that are utilized, none of that is done clandestinely, or that's all shown to Medicaid. There is no mystery. There is a process to go through in order to protect those assets. All of that's disclosed to Medicaid. I have heard people say, we're doing this secretly, or we're doing this, is that legal or not legal? And it most definitely is. Everything that's done is disclosed. There's no mystery. We typically, the attorney that you would be working with would make sure to disclose those techniques to Medicaid when the application is filed.
All right, let's go back to the assumption, if you will, or a scenario where you're not on Medicaid, you have a higher income, or you don't qualify for Medicaid, and you go into a facility or get at-home care for yourself, and you're going to self-pay. You're going to write the check every month, or your trustee, whomever is handling your finances. How is that different? And is there asset protection required then?
So you have the option of saying, I don't want to protect any assets. My goal is to just privately pay the entire time that I'm at the facility, the entire time that I'm at home and getting care. You are welcome to do so. You are welcome to write that check every month. There's nothing wrong with taking that approach. Yeah. And frankly, if you have a significant amount of wealth that's producing enough income to provide payment for all of your care, the conversation you should be having with your attorney is, here are my assets, here's my income. If I needed to privately pay, can I afford to do so? Is that an appropriate approach for me? And if it is appropriate for you, your elder law attorney should recognize that the amount of assets that you have, you're producing, $100 and some thousand a year in income from your assets, so we're never going to be dipping into principal. And so it may not make sense for you to do that asset protection in advance. It may not. Every person is unique. What I would encourage you to do when you're speaking with your attorney is to be very candid with them and let them know what your concerns are. Talk to them about your assets, disclose all of that. They can only help you if they have all of the facts. So it would be appropriate for you to say, I've thought about privately paying. Can I afford to do that? And you may also take the approach, if I privately pay and I run out of money, that's okay. I'm going to run out of money, and at that time, when I'm out of money, I'll apply for Medicaid.
Oh, okay. So that's like a backup, if you will.
It is.
Yeah.
I do like to say, though, regardless of how your care is being paid for, if it's being paid for privately, where you're writing a check every month, if Medicaid is paying for it, if VA is paying for it, if long-term care insurance is paying for it, if your child is paying for it, however it's being paid for, the standard of care remains the same.
That was my next question.
Quality of care, it doesn't change. Those attendants that are caring for you, the nurse that is overseeing your care, the facility that you're in, the care that you're receiving in your home from that caregiver, the quality of care, the level of care is not changing. That caregiver is being paid by some, attorneys would call them clients, by one client. If it's Medicaid, the next client that's long-term care, the next client is privately paying. The attendant, the nurse, has no idea how that care is being paid for, and they're going from client to client, patient to patient, and providing the same level of care, the same meals, the same companionship, the same
type of room,
same type of room. It does not change.
Benefits in that facility.
Doesn't change. You got it.
That's rewarding to know, and certainly something I think people should be paying attention to. We have two calls that we want to try to get in here. Jim says, what is the PACE program, P-A-C-E?
So the PACE program is based upon an area in which you live. There are, so I'm going to speak specifically about Fort Wayne and Allen County.
Okay.
In Fort Wayne, we have a very robust PACE program. And the PACE program is kind of a hybrid of the level of care that you require is the same as if you were in the nursing home. However, you're going to remain in your own home. And then the PACE program oversees things like your medical care. It could address needing food in the home. They have a facility on Lake Avenue that you can come to. There's a lovely, I'm going to call it a gym. I don't know that they call it a gym, but it's a lovely gym that's there. They have a lovely activity room that's there. Parkview, a local hospital, has nurses that are there and doctors' oversight that you can have within the PACE program. So remember I was saying before about cognitive issues or needing assistance with activities of daily living in your age, all of those things will qualify for being eligible for the PACE program. The difference is that you're going to be using that facility in our community there on Lake Avenue and being able to receive care in your home as well. It's a lovely program. It's worth your looking into. I really highly recommend it.
Okay, I've heard such good things about the PACE program. Baz has called in as well, and his question is this. This is timely now, according to the news. When politicians talk about getting rid of Social Security, how is that possible? Are they able to get rid of the funds that you generated? Because there is talk right now about cutting back Medicare and Social Security. Yeah.
Well, this may be a little bit above my pay grade. But so we've all paid into the Social Security system, and without being political whatsoever, I think that some of those funds maybe have been used for some governmental programs, and so people are getting nervous. Is there enough money there to continue being able to provide payment for folks that have paid in so that they have a Social Security payment as they retire and as they age? Are they able to get rid of the funds you generated? Well, it is our Congress, and our Congress, if they deem it's appropriate, would be able to manipulate that program.
Yeah, that was tactful and politically correct.
How'd I do?
We don't know, but that's
it's a concern.
It's a valid concern, and I've heard that for many years, and it hasn't happened yet. And I don't know. I'm just guessing if it was something that was going to be passed,
it would have.
We'd have a lot of notice. We'd say, okay, in 6 years or something.
Yeah. And it would have such an impact on our community and our society. I think that a lot of people rely on Social Security as their retirement.
Yeah.
And so we have a huge aging population. I've said this before, 10,000 people a day hit the age of 65. We haven't even hit our peak. It's the fastest growing population is that senior population. Boy, that would have a huge impact on that part of our society.
And you need to be a good citizen as well. And if you do start hearing more in the news about that and you have concerns, don't hesitate to call or write your congressperson or legislator for your area and give your opinion. That can always make a difference. Okay, almost done here with our show, Bryan. Any last words that you want to give of advice?
Well, I think that some of the most basic documents that you need to have in place if you're thinking about asset protection or not. I think I say this on every show, Sandy. Durable power of attorney, it seems to be so basic, but my gosh, it's essential to have a durable power of attorney in place. I think it's very essential to also have something called a healthcare representative designation in place where you're designating who can make healthcare decisions on your behalf. And that power of attorney is allowing somebody to do what you can do in writing, for them to be able to sign checks for you, make financial decisions for you. Those two instruments are essential for everyone to have.
What if the person that you have chosen moves or they're not in a position to take on that responsibility? Then what?
So the moving part isn't as much of a concern to me as maybe it would have been several years ago. It's a small world. Everything is digital. We can sign online. So the distance isn't as important to me as the person being able to fulfill those duties and recognize the responsibility that comes with it. Normally within those documents, you'll have a succession of people. So if person 1 can't serve, then person 2. If person 2 can't serve, then person 3. So normally you would want in your power of attorney, your healthcare rep designation, to designate who can make those decisions on your behalf if you're unable to do so.
All right. And as far as beneficiaries, why are they important, and what do you need to put a beneficiary on, or name one?
So beneficiary designation, beneficiary designation on assets like checking accounts, savings accounts, brokerage accounts, even real estate in certain states, you can do that. You have to be careful with those beneficiary designations. If your estate plan says, my children can't get the money until they're 25, or my grandchildren get the money at at certain ages, or if someone has special needs at the time that they're inheriting, then we're going to protect that in something called a special needs trust. If you're using your beneficiary designation and the money is going right out to them, you can bypass all of your estate planning, bypass those special needs trusts. So we have to be very careful and judicious when we're making those beneficiary designations and making sure it really does fit with your plan and it makes sense. If I have a person that has more than one child and we may be treating children differently, or we're putting qualifiers on when they get the money, those beneficiary designations bypass that. So we have to be very careful with it.
Thank you, Bryan.
Yeah. Thank you, Sandy.
You.
I appreciate it.
A lot of information for you to digest and to think about. And of course, every Wednesday night, we'll have more information to help you with your choices in your life ahead. Bryan Nugen, thank you for coming.
Thank you, Sandy.
Thank you all for watching. Stay safe and stay healthy. We'll see you next week.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, specializing in estate planning and elder care law, emphasizing independence and the quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.